A very warm welcome to everyone. Am I audible?
Yes,
Yes,
ma'am.
ma'am, clearly.
Okay.
Yes, ma'am.
It's a pleasure to welcome you all again for the 30-hour certificate course on drafting, pleading, and conveyancing organized by School of Law, Fairfield Institute of Management and Technology in association with Pro Bono Club. We have with us today our esteemed speaker for Module 7, Ms. Abha Malhotra. Ma'am is a senior counsel for the Union of India at the Delhi High Court and is managing partner at Pleaders, a leading law firm. Ma'am has more than 2 decades of experience and has expertise in writ and appellate jurisdiction as well as arbitration matters. Ma'am has also handled many landmark cases from government policy to taxation to service and educational matters. Ma'am was also and continued to be on the panel of many educational institutions like Jamia Millia Islamia University, FITG, Presidium School, etc. I welcome you, ma'am, in today's lecture.
Thank you so much. Thank you. And it's an honor and a privilege to be here. I thank you for this. And before I start, I would also like to say that now I'm almost in my 30th year. So that's an amendment to what you just talked about me. And also that I'm an arbitrator with the Delhi International Arbitration Center and some international organizations. So just to add to that. Now, before I start, I need to have your permission. I have prepared a PowerPoint presentation. So I would like to share that. Can I?
Ma'am, you can send it to me. Arushi, ma'am, will it be feasible for you to share it?
I am a little not so technologically savvy. I can share it on my own if you allow me.
I will make you a co-host, ma'am. You can share on your own also.
Okay.
Just give me a second.
Yeah, thank you.
Yeah.
Thank you.
Now you have the permission to share screen by Zoom. Yeah.
Okay, thank you so much. I hope you can see it.
Yes, ma'am. Clearly visible.
Okay, thank you so much. So as you can all see, the topic is pleadings in arbitration. And I believe this is a course on drafting. So as you must have already heard various people on various aspects of drafting, today we are going to talk mostly about pleadings within arbitration proceedings. Now, before we go forward into this topic, you should be aware of the various stages in arbitration. So just to give you an overview, the arbitration clause in the parent contract is a must before we initiate arbitration. Without that clause in the contract, you cannot go for arbitration. And if that clause is there, then your remedy to a civil court is barred. Then you have to go for arbitration. So there has to be an arbitration clause in the agreement. Then there has to be some dispute that arises between the parties. After that, there is an appointment of an arbitrator. Now, Section 8, Section 11, which I have referred here, is basically when you apply to the court for the appointment of the arbitrator, but you can do it privately also under Section 21. And thereafter, once the arbitrator has been appointed, your pleadings and hearings, etc. start, which are governed from Section 18 to 27 of the Arbitration Act. And then you have the post-award remedies, etc. So today's talk, I am mostly going to focus only on the pleadings during arbitration. Before I move forward, you know what are pleadings by now, I hope. That must have been taught, but just as a reminder, the Order 6 of CPC says pleadings include a plaint and a written statement. That is it. Similarly, the pleadings in a writ petition would be a petition, the writ petition and the counter affidavit. And similarly, in the arbitration, you have a statement of claim and a statement of defense. This is because arbitration is basically a creature of contract. So we have a contract, which is a commercial dispute. You need to know the essentials of a contract before you go in for arbitration. Consent is key, the contractual framework, enforcement via contract law, freedom of choice, limits of power, all this comes from the Contract Act, the Indian Contract Act. Also, we can borrow from UK, etc. But unless you understand, you have a gross understanding of the Contract Act or the features of contractual law, you cannot really proceed in arbitration. And before you plead a case, you need to know the basic law, the governing law. You need to know the facts and the law. Only then can you make a well-drafted pleading, so to speak. So these are just to remind you, of course, you would be doing it in your course. What are the essentials of the contract, the offer, acceptance, consideration, the capacity to contract, that it should be legal and not voided by any of the various statutes, misrepresentation, fraud, etc. And the intention to create a legal relation. The parties have to be ad idem. Having spoken about what leads into making of a contract, then what goes into the arbitration agreement. Now, what happens is when there's a contract, let's say between A and B to do something, it is in the making of that contract that you include the arbitration, that in case of disputes, we will refer this matter to arbitration. That has to come in whatever language you may say, but this intent must come in that contract itself for arbitration to be birthed at all. Now, just a little something on the cases, just to give you a flavor on the arbitration agreement. We've been having a whole lot of cases coming up in the Supreme Court recently also, but these are some landmark cases. In state of UP versus Ramnath, the arbitrator is a creature of an agreement, and he is bound to enforce the terms of the agreement. Very many times we find that when the arbitrator goes beyond the terms of agreement, that is the parent contract, then the award can be vitiated and can be challenged. So before you plead for the arbitration statement of claim or statement of defense, whatever you are trying to plead in the arbitration, you must be mindful whether you are appearing for the claimant, whether you are appearing for the respondent, or whether you're an arbitrator, that you have to limit yourself to the terms of the agreement. We cannot go beyond that. And these are certain cases dealing on this aspect. State of UP versus Ramnath International Construction, as well as Food Corporation of India versus Chandu Construction. Now, in Jagdish Chandar versus Ramchandar, which was really a case of 2007, it was that clause which determines the fact that you will be entering into arbitration. You have to ensure that this is not something vague or agreement to get fresh consent or a further consent. This has to specify that yes, here and now we consent that in case of a dispute, we will be going for arbitration. All these aspects must be clear with you before you start. You see, many times people say pleadings is the start of a case. It is not really the start of a case. Pleadings comes only once you have conceptual clarity and contextual familiarity, both with the facts and the law. So whatever aspects of law are there, You must be mindful of those. You should research those before you start or attempt pleading in any field, whether it is writ, whether it is civil, whether it is criminal, whether it is arbitration. You have to be clear of the law and you have to be clear of the facts. And sometimes, I can tell you by experience, clients don't open up about the facts very well. They will only tell you their side of the story. They will not tell you the balance. You have to probe. You have to really probe to find out the truth, because otherwise you will bring a poorly drafted pleading before, let's say, an arbitrator or a court, and then you will have to face the brunt of it. It would be a sheer waste of time, because sometimes you can be sent back to the drawing board. So all these things have to be gone into before you take up a pen and start the pleading itself. Now, what is the objective of pleadings, whether it is an arbitration or any other dispute? It is to give each side the intimation of the dispute and to take away the surprise element, to enable the court to determine the issues at hand and to be able to diminish costs. This is a very long-standing established principle established by Privy Council sometime in the 1930s, that no amount of evidence can take the place of pleadings. So unless you pleaded something, no matter how much evidence you bring, it cannot be taken account of. Your pleadings has to be very, well, I won't say you go to the extent of being too brief. I'm not in favor of too much brevity and too much prolixity. There has to be a balance between the two. You should know all the things that you need to put on paper, as well as those things which you need to avoid. That balance has to be achieved by you. That brings me to what are the essentials of pleadings. I have already discussed that Order 6 of the CPC discusses the pleadings, and I would advise all those who are participating in this certificate course to really go through not just Order 6, but 7, 8 also. Because 7 talks of plaint, 8 talks of written statement, and those are the things that are mimicked in all the other proceedings, whichever proceedings you go for. And the primary elements of pleadings is that you have to plead the material facts and not evidence. Now, what are the material facts that you have to sift? If there is a series of emails, and let's say out of the 10 emails, your client brings you 6 and says, "Ji case bana do." So you will have to probe, you will have to ask pertinent questions so that you have the entire factual matrix before you pick up your pen and start pleading. So all the material facts, and what is material, what is immaterial, that you will have to judge. They say pleadings and drafting is an art. It is a skill that cannot really be taught. It has to be learned through experience. So you will know by and by what is material and what is not material. Material is that goes to the root of the matter. So those things you must plead. The condition precedent to the contract, etc., you must specifically plead those. And you have to give the particulars. For example, if you say, my property was under attack, without giving the property number, the property description, where it is bounded in the north, south, east, west, unless you describe it fully, how will the court know which property you're talking about? So that's what I mean to say, that all the particulars have to essentially be given, and there's always a presumption of the law. So you must know your law. And finally, pleadings have to be signed and verified. Now, this thing is taken very lightly, especially by the new generation, I would say, because they say, "Humne bana diya, baki ab aap karo." But the fact is that it should be signed. And if you are appearing for a company, the board resolution should be in place. It should be verified. All those things you have to take care of while you make the pleadings. Now, what are the components of pleadings in arbitration? First of all, there is the notice. Now, you would say that notice is not part of what the CPC says about plaint and written statement. But I tell you that notice, whether it is of arbitration or whether you're doing a case of 138 of the Negotiable Instruments Act for a check bouncing case, unless you can make a foundation of your entire case in that notice, you have to really study your case before you make the notice. Only then can you be able to draft the statement of claim. So notice should not be taken lightly. In fact, you need to do deeper work before making the statement of claim while making the notice, because your claim amount, etc., should be well calculated. Later, you can't say, oh, I left that and I left that. Now let me go back to the drawing board. So you must go through the entire factual scenario and make the notice. And thereafter, what is technically called the pleading, that the making the statement of claim, you will give the factual narrative of the events leading to the dispute and the remedies sought. The quantification of claims is important. Similarly, if you're on the respondent side, then the reply to each and every averment or allegation made by the claimant, you have to meet, respond to. And what you don't deny will be considered admitted. So therefore, you have to be very careful while making the statement of defense also. And if you have to give factual narration for that as well, you must admit it, because you can say that these facts as alleged by him are wrong. Actually, these are the facts. So that must also come in your statement of defense. Then we have a counterclaim, because you see, arbitration deals with mostly contractual disputes, and they are mostly claims कि मेरे को इतना चाहिए, मेरे को उतना चाहिए, या हमारा इतना नुकसान हुआ. So therefore, sometimes the respondent brings what is called the counterclaim, because one settled issue of law is that if you make a prayer before the court or the tribunal, the arbitration here would be the tribunal, only if you make a prayer can it be granted to you. And the respondent cannot, in his statement of defense, make a prayer other than that you dismiss the claim. Beyond that, you can't make a prayer. So if you have a quantification required that, look, he's asking for 100 rupees, but actually he owes me 75 rupees. So to ask for that 75 rupees, you will have to make a counterclaim. And all the elements that go into making your statement of claim will be incorporated while you make this counterclaim, even if you're appearing for the respondent. Then we come to the rejoinder. Now, rejoinder is not mentioned as part of pleadings under Order 6, but it is mentioned as an additional pleading under Order 8, Rule 9. And this principle has been taken in the writ court also, in the arbitration proceedings also, on most forums it is taken. The only thing is that you need the leave of the court, and more often than not, the arbitration tribunal or the court grant you leave to file the rejoinder. Only the plaintiff or the claimant will get an opportunity to file the rejoinder, not the respondent. So the claimant has two opportunities to file the pleadings. One is the statement of claim, and then there is the rejoinder. Whereas the respondent, if he's not bringing a counterclaim, then he has only one opportunity, which is the statement of defense. Now I come to the 4 golden rules of pleadings. These, I think, by now you would be aware of, because these are the same for all fora. whether you're before a court of law, before a writ court, a trial court, before a consumer forum, before any tribunal, even the arbitral tribunal. Pleading should state facts. The law you can talk about only when the arguments arise. Then the facts in the pleadings should be material facts. Pleadings should not state the evidence. There is an opportunity given to both sides to lead their evidence. And so you can't go on and on and on ad nauseum repeating the same story in all the paragraphs. You have to give each point of conflict very briefly but succinctly. Now, what are the provisions that govern the statements of claim and defense in arbitrations? Section 23 of the Arbitration and Conciliation Act. This is again a repetition of all that I have just said, that you must provide the facts supporting the claim, the points of issue, and the relief sought. Quantification is very necessary. Then time limit, etc. What I want to also tell you by my experiences, in one case where I was the arbitrator, what had happened was this was a case against the builder. In fact, the builder had brought the claim. They brought a claim for damages and specific performance, and they said that we have incurred a loss of 4 crores. Now, in their pleading, nowhere did they state how they met with the loss of 4 crores, nor did they lead any evidence. So as an arbitrator, how can I award the 4 crores to them unless it has either been pleaded? And if it has not been pleaded, then you can't allow them to lead evidence on it also. Therefore, the pleading becomes of great importance. So again, I say, like, if you are making a statement of claim before an arbitrator and you are asking for a claim of, let's say, 10 lakhs or something, you must not only say how it has arisen, but you must also read up the contract law. Is it governed by Section 73 of damages, etc., or is it something off your hat which is not legally tenable? All these things you must bear in mind while you're drafting your statements of either, the claim or the defense. Now, here I've tried to bring to you a gist. DIAC is the Delhi International Arbitration Center, where I'm also an arbitrator. Now, they have their own rule book for drafting of the statement of claim. You can go through this. This is very important. Sometimes what happens is, if the name, description, etc. is wrong, then that can lead to the mortality of the case. These things we take very casually sometimes, but they should not be taken casually. You see, you're all budding lawyers, and as lawyers, you must learn to read like a hawk and not like a sparrow, because it is, as they say, the devil is in the detail. The detailing of it, how well you detail your drafted pleadings will determine how successful you are. And your relief, the words you use for the relief, that the amount you've claimed, the quantification, how you've come to that figure, the calculation behind that figure, the thought process behind that figure, the dispute behind that figure, all that must be pleaded. And you must annex certain documents that would help your case, the relevant agreements or whatever else is supporting. The supporting documents must be annexed with the pleadings, because whatever is annexed as part of the statement of claim or defense will be read as part of it. So it helps for the brevity part of it, that you are brief in what you're saying in your pleading, but you're annexing the entire document so that if we have to split hairs, we can do it. The document is before us. these are again the various rules that I was talking about, the particulars of the arbitrator, statements as to the applicable rules, the orders of the court. Now, if there's a court order saying that so-and-so has been appointed as an arbitrator, that must be annexed with the statement of claim. Statement as to whether under any order under Section 9 has been passed or not. Section 9 deals with interim applications, etc. So all that, as we go back and forth, the knowledge of law. Then the final terms of reference in furtherance of the provisional terms. Then the value of each relief sought, along with the aggregate amount and quantification of the aggregate claims. All this is part of what is mandated by the arbitration center that you must. Now, arbitration center actually deals with the institutionalized arbitration. We also have ad hoc arbitrations where privately an arbitrator is appointed, but these same rules should be applied by the arbitrators themselves. What is the quality of a good statement of claim? The reasoning, as we have with the orders, like all the higher courts, the Supreme Court, the High Court says you give a well-reasoned order. Similarly, you give a well-reasoned statement of claim. If it is well-reasoned, it becomes easier for the judge. After all, the success of a lawyer depends on whether or not they can think like a judge. So if it is well-reasoned, you've given supported reasoning for bringing that claim before the tribunal, that would only help you. You have to give specific claims. It can't be a vague thing. Pleading can never be a masterpiece of vagueness. You have to be very specific in your pleadings. What is it you want? How much you want? How is it that you've come to that calculation? It should be crisp and precise, and each claim and prayer to be quantified. This I'm going on repeating because it is of such great importance. I've seen so many cases fail because this was not well quantified. This prayer or the claim was not well quantified. So therefore, you come up with an order against you, then you go to the court. It just adds to the litigation process and the misery of your client if you don't pay attention to these qualities. Similarly, as was with the drafting of the statement of claim, we have the drafting of the statement of defense. We must always give not just the facts, but the chain of events that lead up to those facts, how the differences started, what was the reason for the dispute, how the dispute sort of precipitated, that all should be highlighted. And the arbitral tribunal, how does it derive the jurisdiction, the terms of the reference to the arbitration, all that should be well pleaded, and that they have agreed to submit themselves to the arbitral tribunal. That also, naturally, the parent contract comprising of the arbitration agreement, that should be annexed with the pleading. Then in your statement of defense, your defense should obviously be there, and you cannot ask for much relief unless you're asking for a counterclaim. The only relief you can say is dismiss the claim. And whatever supporting documents you need to bring, that you must do due diligence. As an arbitrator, I tell the parties from day one itself that you do your due diligence. Once the evidence starts, I will not allow any additional documents to be brought, any amendments to be made. So whatever nut bolt changing you need to do with your pleading, you do it initially itself, and that will stand you in good stead. Now, this is just a sort of an encapsulation of what I said. These are from the DIAC rules for drafting of statement of defense and counterclaim. This is a rule of natural justice that you have to specify the time You have to adhere to the time given. Normally, like your CPC mandates 30 days for the filing of written statement. In arbitral proceedings, normally we give up to 4 weeks. And nothing is accepted. Even where I'm appointed ad hoc arbitrator, I'm not under any institution. Even there, I say I will accept nothing unless the opposite side has been served. So these are commonsensical, fair practices that one must establish. And the plea of set-off and or counterclaim, if any, that has to be filed along with the statement of defense. You can't file a statement of defense and then later stage you say, I have a counterclaim, also allow me to file that. That will normally not be allowed unless there are very exceptional circumstances. That's why in the beginning itself, I said you have to really think through the process. You have to go to the end before you start the beginning. You have to think through what you want from the court, from the tribunal. You have to go through the stage. You must be ready to meet the challenges that you meet in the court also. Will it stand the scrutiny of the tribunal? Will it stand the scrutiny of the court? And then you bring your pleadings. And if you fail to adhere to the timelines, it may result in your either the claim. If the claim is not brought on time, then the rules very specifically say that the arbitration proceedings be terminated. And similarly, if the statement of defense is not brought within time and there's no application for condonation of delay, then your defense is liable to be struck off. That means everything that the claimant says will be accepted and admitted, and nothing you say will be heard. So it is better to adhere to the timelines. This is again a little of what I had already said. Now, the important aspects of drafting a statement of defense is that you take up all the legal and factual issues raised by the claimant. That means you go para by para, word by word, line by line, and meet those. You must be to the point. Meeting each of his averment or allegation doesn't mean that you go into your own lengthy story, but you must meet them precisely, concisely, succinctly, and bring your point of view to the fore. And you have to justify your position. If he's saying that you owe him some money, you have to justify your position, why that money was not paid, or why you're asking for a set-off or counterclaim. All that justification must be a part of the statement of defense. And then you must follow a chronological order. I can share my own personal training as a lawyer. When I started very young, the senior I had was a very strict senior. And he would say, you make a list of dates. Till today, there's this practice, even in the writ court, along with your petition, initially you bring a synopsis or a list of dates. And I tell you how that helps you. Because the claimant or the client is full of his own story. Now you ask him either to write it down for you in an essay form, or you write it down yourself in an essay form. And then you go date-wise. And then you make a list of those dates chronologically. Automatically, things will start making sense to you, and you will know where the gaps are. You will ask pertinent questions. So this list of dates is a very important trick, really, in knowing how to master the case, going to the grip of the case. And unless you have the grip of the case, you cannot plead very well. So whatever the chronological order is being followed by the claimant, similarly, the respondent must also, if there's an MOU, then thereafter a registered lease deed, thereafter some payments were made, and thereafter no payments were made. Supposing this is the line of the dispute, then you must say, look, yes, MOU was made, lease deed was registered, I made these payments, but then I tried to make and he blocked my payment or whatever. So you follow the same chronological order. And then the requirements, like I accepted from the Delhi International Arbitration Center. All the arbitration centers have their own set of rules, whether it's Hyderabad, Mumbai, or Singapore, or Madrid, or London. All of them have their own arbitral rules. And wherever you have to bring the claim, you must follow those rules also. Apart from your own experience of how to draft, you must go through those rules and see whether those rules that are applicable to you, you have applied those. Otherwise, you must apply them or you will get into a problem. Then, of course, the same, you attach all the supporting documents. Now I come to the counterclaim and the rejoinder. First, we had the claim. Thereafter, we had the statement of defense. And along with the statement of defense, I told you that the respondent has the opportunity to bring a counterclaim. That is really his own prayer, quantified prayer. कि उसने 100 मांगा, वो तो नहीं मैंने देना, लेकिन मैंने अपना 80 मांगना है. For that purpose, we bring a counterclaim. Counterclaim has to be really like a statement of claim. So it is the respondent's statement of claim that he is asserting against the opposite party's statement of claim. Now, what happens is, like in an arbitration, somebody has filed a statement of claim and the respondent says, I will want to file my counterclaim. That does not absolve him of the duty to file a statement of defense. So he files the statement of defense and the counterclaim together on the same day, preferably. The statement of defense will kind of meet the allegations of the claim, and the counterclaim will set up his own new case. And therefore, the rejoinder that the plaintiff will or the claimant will bring will be an answer to the statement of defense. And the counterclaim will begin a new series of pleadings. जैसे claim का हो गया claim, statement of defense and rejoinder, वैसे काउंटर क्लेम जब फाइल होगी तो काउंटर क्लेम का एक रिप्लाई आएगा और फिर उसका रिजॉइंडर आएगा. दिस इज द सीरीज हाउ इट follows. Now I come to certain controversial areas of pleadings in arbitration. Now, I don't know how well aware you are of the arbitration proceedings and how much of the arbitration law you're aware of, how much you've been taught. But you see, whether you deal with part 1 of the Act or part 2, part 1 applies to the domestic arbitrations and part 2 applies to the foreign arbitrations. The one very tricky issue is third-party funding. And a lot of jurisdictions have separate laws on them. So this area becomes tricky in the sense whether to plead about it or not. Because if you don't plead about it, it could amount to suppression of material particulars. And if you do plead to it, then you admit, you see, this becomes like champati. Champati was banned under the common law. From the English times, champati was banned even when India adopted the contract law, etc. So third-party funding has always been looked down upon. It's like somebody sponsoring your litigation. That was always found to be against public policy. But now tolerance has grown and people say, okay, we will finance this dispute and we will also enjoy the fruits of this dispute. So since the tolerance has grown in some jurisdictions, it depends which jurisdiction you're in. So there can't be a straight jacket formula for this. You will have to check where you are filing the statement of claim, in which jurisdiction you are. Because I also go for international arbitrations. Some places you plead about the third-party funding, some places you omit. It depends on where you are actually. So this is one aspect that you should be mindful of, that you don't come out in the open where it is looked down upon. And second controversial area that I have picked up as a matter to talk about today is the accepted matters. Now you will say, what is this accepted matters? Now, we have a lot of disputes, let's say, between the railway contracts or the CPWD contracts. These are all state contracts, right? The state is contracting with some contractor, and they have a general format of contract. And those are called the general terms of contract or the standard form of contract. And there they have various clauses which are accepted from the arbitration. Because their contract says, yes, we will go in for arbitration in case of a dispute, but X, Y, Z area of dispute is accepted from arbitration. So what happens is, if you bring in pleadings and claims of the accepted matters, for example, let me give you by example, whether it is the railways contracts. I've recently done one railways contract also, where things like loss of profit and idling of manpower and certain of these kind of claims were accepted from the arbitration. Yet what happened was that the claimant brought those as claims, that I asked for this much amount as loss of profit and I asked for this much amount as idling. Now what happens is, the arbitrator, unless it is pointed out to the arbitrator, he may not know, he or she may not know that this was accepted. It has to be brought to their notice. And if it is not brought to their notice, and if they're not aware, like when I'm an arbitrator, I put it to the parties. But in a case where the arbitrator is not aware and it is not brought before the arbitrator may pass an awarding such claims which were accepted. Then it will be challenged before the court, the High Court or the Supreme Court. And then the Supreme Court will say, go back to the drawing board, start with your whole exercise again of arbitration. So therefore, in your greed to ask for accepted matters, you plead those, which results in a bigger loss to your client. So this aspect you should be mindful of whether or not to incorporate them. This is something that you must put your mind to. Now this was yes. Now what is poor pleading? Poor pleading, as I said, it should not be a masterpiece of vagueness. Then when you bring inaccurate or misleading information, that could sort of irritate the tribunal in so much as that they lose their trust in you. They may feel that everything you're saying is a lie. You see, one lie is caught, then everything is looked at with suspicion. So you must be very honest and accurate, and misrepresentation, by the way, is also a ground for voiding any contract. And the same principle applies when you're pleading before the tribunal. If you're misrepresenting something, you're giving misleading information, then you could be penalized for it. Then the lack of structure. Unsubstantiated claims. Like I gave you the example of the builder asking for 4 crores without showing how, either in the pleadings or by way of evidence, nothing was shown. How did he ask for those 4 crores? So you have to substantiate your claims. Then when you're giving your factual statement, if it is found to be inconsistent or there are contradictory statements, then again you have the chance of losing out. And then, of course, the non-compliance of the arbitration rules of whichever center that you are with, that could result in your loss. What happens if you bring a poorly pleaded document in the arbitration proceedings, whether it is the statement of claim, whether it is a statement of defense, whether it is your counterclaim? What happens if it is poorly pleaded? Now, there's a loss for both the system as well as the parties. For the system is that there is a loss of confidence. Naturally, if parties have to go twice over, thrice over, there have been 3 rounds of litigation starting from the arbitration, then they are going to lose their hope in the system. So it's a crumbling of the system that could result because of a poorly pleaded document by you, and then it increases the workload. For instance, as an arbitrator, I can tell you, if I have something poorly pleaded before me, it increases my work. And when it increases my work, then the amount of research that I would perhaps be doing into whether or not to award their claims, I'm just trying to straighten out the issue here for them. That leads in a loss for the arbitral system. And then what is the loss for the parties? The loss for the parties is that if your pleading is bad, it may result in the mortality of the case and your client losing out, which otherwise he may have won had you pleaded well. It will increase the cost. Naturally, if you have 1 round and you have 3 rounds of litigation for the same thing, the cost will multiply. Then the number of hearings, damage to the business relationships, and the delayed resolution. After all, what was arbitration? This is an alternative dispute resolution mechanism. This was brought because litigation takes too long and is too costly as an alternative method for dispute resolution. But if you are going to delay it and increase the cost of it, then it becomes redundant in that sense. So therefore, for both the system as well as the wellness of the parties, it is better that your pleadings are properly drafted. Now I come to a very interesting aspect. I was wondering whether or not to include it, but I then thought, let me just talk about it since we are talking about pleadings in arbitration. This is section 16 of the Arbitration and Conciliation Act, which is competence of the arbitral tribunal to rule on its own jurisdiction. Now, I'll just read it out from the BARE Act. Competence number 1, the arbitral tribunal may rule on its own jurisdiction, including ruling on any objections with respect to the existence or validity of the arbitration agreement. And for that purpose, A, an arbitration clause which forms part of a contract shall be treated as an agreement independent of the other terms of the contract, and B, a decision by the arbitral tribunal that the contract is null and void shall not entail ipso juro the invalidity of the arbitration clause. This is what we call the competence. And the fact is that it is controversial because the arbitrator himself gets to rule on his own jurisdiction. And unlike the courts, arbitrations are really in the realm of a private trial, so to speak. So, and thirdly, why I'm relating it to pleadings is because unless you know that this exists, you cannot raise it. So if you have to raise it, like whenever we have to file a section 16 application, we have to do it at the start of the matter. It does not help if you realize that this application lies at the time of the trial, really. So therefore, again, it brings us back to the point that you have to know your law. And therefore, all these pleas that I have given you, these can be taken up. And these are some of the judgments on this aspect, which is called competence. Now, award in excess of jurisdiction. The arbitrator is not empowered to rewrite the terms of the contract. This Supreme Court has held, but this is no longer res integra. It has been laid down over and over again that you have to contain yourself to the terms of the contract. So why would an arbitrator rewrite the terms of the contract? That is because of some poorly pleaded contract and his opponent not pointing out that this was not a part of the contract, and therefore the arbitral awarding something that was not a part of the contract. It all starts with a poorly pleaded case before the arbitral tribunal. So, of course, the arbitrator cannot act arbitrarily, irrationally, capriciously, or independently of the contract. And he has to work within the terms of the contract. These are, of course, there. Now I come to the rules of procedure. Because when you are making the pleading before the arbitral tribunal, you must be aware of Section 19 of Arbitration and Conciliation Act, which basically says that the arbitral tribunal is not bound either by the CPC or the Evidence Act. But there are judgments of the Supreme Court which say that yes, you are not strictly bound by it, but you can adopt the principles of it. And since we are not bound by the CPC, the parties are free to agree on the procedure to be followed. If they are unable to agree, then of course the arbitral tribunals normally follow the CPC and the evidence, at least the principles enshrined in them. Maybe not the hair-splitting level, but the principles enshrined are followed. And the power of the tribunal includes the power to determine the admissibility, relevance, materiality, and weight of any evidence. This you should be aware of before you start the pleading. Now I come to the language. As per Section 22 of the Arbitration Act, the language is really a choice of the parties. You can choose more than one language. You may also decide the language of the written statements, hearings, documents, as well as the arbitral award. Now, the tribunal will decide the language upon failure of parties to do so. I, for one, have not either been an arbitration counsel or an arbitrator in any case where any language apart from English was used. But I stay in Delhi. So what happens in the interiors, I really don't know. Now there is a push towards the use of the vernacular, but you should be aware when you make the pleadings that it is the choice of the parties. For instance, I am also an arbitrator with the International Center of Arbitration in Madrid. Now they give me a choice. There's an arbitration in Spanish and there's an arbitration in English. I have given a written declaration that I will not take up any matters which are in Spanish because I am not comfortable with that language. I don't know that language very well. I will only take up matters in the English language. But before you pick up the pen, you should know which language you're going to use. And when you are making the pleadings, you must also be aware, as I said many times over, even today, that pleadings in arbitration really mimic the pleadings before the court. They may be given a different nomenclature. Instead of a plaint and a written statement, it may be called a statement of claim and a statement of defense. But all those aspects that you put into a plaint, you will put into the statement of claim. Whatever you put into the written statement, you will put into your statement of defense. And there are certain things which are essential, like your cause of action, like your jurisdiction, the valuation, all that you need to plead. So in that sense, yes, the pleadings before the arbitral tribunal mimic the pleadings before the court. Again, as I said, it's arbitration is more like a private trial. So arbitration is renowned for its privacy. You see, these are closed doors meetings that happen. Unlike the open court, anyone can walk into the court and observe the proceedings. Whereas in the arbitration, these are behind closed doors. So they are private in nature. That doesn't mean that they are necessarily confidential, because the arbitrator is bound by a certain level of confidentiality, but the parties are not. Parties are not. So this is something that you need to know. And the level of confidentiality is really contingent on the factors such as the rules of the arbitration administering institution, which jurisdiction you're in, which center you're in, all that, all those rules, depending whether you're in Delhi, Hyderabad, Madrid, wherever you are, those rules will govern the level of confidentiality. And then the arbitration agreement itself, additional agreements entered into by the parties, as well as the relevant laws. If nothing is concurred by the parties, then the degree of confidentiality can be decided by the arbitrator. So let me give you an example. For example, in fact, I had also given a suggestion when I was asked by the Indo-Pacific Bar Association to make a speech. I had said that, like we have the benefit of case law for courts, we should have the benefit for the arbitral awards as well. As an arbitrator on a certain issue, I should have the benefit to know that in that given situation, with certain similar facts, how did the arbitrators before me decide the matter? That was never available when I started out. Now, very recently, I think last year only, the Mumbai Arbitration Center has entered into an agreement with one of the publishers to bring those awards which are redacted. That means the identity of the parties is removed, but only the issue is brought forth and the award given is brought forth. So that helps the arbitrators to decide in a particular manner and to establish the rule of law. You see, the whole purpose of precedents is that everyone doesn't do their own thing. There's something called the rule of law. So you can expect a certain decision in a certain set of circumstances. Similarly, it should be for the arbitration law. Sorry, I think I skipped a slide. Yes, this is again speaking on the confidentiality optionality. The section 42A was inserted later in the 2019 amendment. And this again depends on the jurisdiction, as I said, how much confidentiality to maintain. Singapore is known for upholding the confidential nature of a tribunal's deliberations, whereas UK has not specified the same. This is just to bring an example how jurisdictions can differ on this aspect. Now, why did I make this slide? As I said, arbitration is an alternative dispute resolution mechanism. And one of the primary advantages is its speed and efficiency compared to traditional litigation. Now, this also must reflect in your pleadings. If your pleadings are very lengthy, if your pleadings are beating around the bush, they're not very specific and concise, this can defeat the object of arbitration. And we must ensure, as responsible lawyers also, for whichever party you may be appearing for, the claimant or the respondent, that you avoid lengthy court proceedings. And the timeline and pace now, what happens is, I'll tell you, it's a matter of practice, especially in the Delhi High Court, where I deal with a lot of arbitrations, that at the very outset, maybe in the first hearing or two, a schedule is given by the arbitrator. By such and such date, you file your statement of claim. By such and such date, you file your statement of defense. By such and such date, you file your rejoinder. Then you file your affidavit by way of evidence. Then you bring your proposed issues. So that by the next date, you are at the stage of framing of issues. And this has to be, I am in support of this, considering that this is supposed to be a faster and quicker way of disposing matters. There's a section 29A which has been amended also. It has been inserted in 2018, if I'm not wrong. 2018, I think, which says that after the pleadings are complete, the arbitral award has to be out within a year. It can't take years. Within a year means that if 12 months have passed and you are unable to make the award, then the parties have to go back to court and seek an extension of time. And you have to give reasons for the extension of time. And therefore, arbitrators are not at all going to give you adjournments on the asking. I, for one, impose costs. That's the only deterrent to adjournments. So it's not as cushy as it looks. Strict timelines means greater stress for the parties, for the lawyers, as well as for the arbitrator. Now, this I have already discussed, but this is with the case law, that if you fail to file the statement of claim within time, the proceedings are terminated. And if you fail to file the statement of defense, it doesn't terminate the proceedings, and it isn't treated as an admission of the claims, but the right to file the statement of defense stands forfeited. Supreme Court has given umpteen number of judgments. I've just picked up one here. Defects in authorization. This is just by way of example. If you remember one slide, I said, what are the elements of pleadings? And it was the signing and verification, which I said is taken very casually by people. Now, this is one example. What happened? This case went into for arbitration, and during the leading of evidence, the opposite side found that the board resolution was not there. It was not proper. And therefore, they said that this document cannot be looked into because the person bringing it is not authorized by the board to bring it on behalf of the company. Now, then what happened? The arbitrator said, this is really an irregularity, and I will give a chance to the party to correct this irregularity, to cure the defect. So then the person opposing it went in challenge to the court. The court said the arbitrator is well within its competence to cure the defect. It is in accordance with the rules of principles of natural justice. Thereafter, they went again before the division bench, and they also said that this is doable by the arbitrator, that the substantive rights of parties should not be compromised on account of procedural irregularities which go to the root of the matter. But just to tell you that one board resolution was not brought forth. This was a lapse. To correct that lapse, not only did the arbitrator what he could have finalized the claim, but he first decided it. Then against that, there was a section 34. Then again, an appeal against the section 34. So 3 rounds of litigation to decide that one aspect. That's why I say that poorly pleaded can really result in a loss of money and time to the parties. This is again on that same judgment. I will not get into too much of this. This section 28A is very interesting. which says that you can apply principles of equity and fairness and justice also in arbitral proceedings. It's interesting, so one must take a look at it. Then these are certain ICC arbitration rules, like I had given a flavor because the DIAC rule handbook is quite thick and I didn't want to burden everyone with so much reading. So I just gave you an excerpt of 2 slides from the DIC handbook. Similarly, ICC is the International Chambers of Commerce. They have a very thick rule book for arbitral proceedings. And wherever in, let's say, any center, their own, supposing DIC did not have their own rule book, then they would go to ICC. So many centers who don't have their own rule book, they rely on ICC. It's the accepted thing internationally that you can go to the rules in ICC. So this is just to give you a flavor. In 21, after the COVID pandemic, they made a provision for virtual hearings and to do away paper filings. So this is procedural when you make your pleadings accordingly, and consolidation to the joinder provision, etc., as well as for the time limits. Now, ICC brings in their rule book that you disclose third-party funding agreements. Since I have talked about this issue, I thought I'll let you know, but depends on jurisdiction to jurisdiction. Then this I had already spoken on was the time limit of the arbitral award. I told you Section 29 was amended, and if the Act says within 12 months you bring the award, and it is extendable maximum by a period of 6 months. So you can't kind of sit over it and bring lengthy pleadings and then keep on having adjournments. The sword hangs on the arbitrator's head. So he's not going to accommodate you, he or she is not going to accommodate you with those adjournments. You have to adhere to the time limits. Then, of course, we have the amendment of pleadings. No talk on pleadings, and drafting pleadings would be complete without talking about amendment. The amendment of pleadings draws sustenance from CPC provision, Order 6, Rule 17. Now, this is a flexible thing. This is to meet the ends of justice. Supposing you made a mistake, you are allowed to rectify it, and therefore, as long as you're not changing the color of your claim, you're not changing the nature of your claim, कुछ रह गया गलती से, वो आपने amend करना है, उसके लिए you can bring amendments of pleadings, and the principles applying in 617, the judgments there, what the thought process they've given Supreme Court, etc., that will be applicable even in the arbitral proceedings. So here, what I'm saying is that we are not bound by CPC, but the principles apply. And within the Arbitration Act, like we have Order 6, Rule 17 in CPC, pari materia, we have Section 23 in the Arbitration Act. So you can amend or supplement your claim as per Section 23. Then this Patel Engineering Company was an important case in the interpretation of Section 23 of the Arbitration Act. And it says that, yes, you are allowed to amend the statement of claim and the statement of defense, but you cannot travel beyond the scope of reference or permit another claim to come in and seek adjudication of it without following the due procedure prescribed in the arbitration agreement. So this is really in the nature that you use it as a shield and not as a sword. You know, you can't sort of jeopardize the other party by bringing in new claims or changing the nature of your claim. And of course, if you change your claim, then the opposite side will also be given an opportunity to amend their statement of defense. That follows. Now I come to the point, when is it initiated, the arbitral proceedings? When are they initiated? When does the cause of action to initiate arbitration proceedings get started? It gets started at the time of the dispute. X tells Y, you give me this much money. Y says, I will not. What is the remedy before X if there is an arbitration agreement in the contract entered into by them? First, he can send a notice of invocation under Section 21 of the Arbitration Act. Now, what happens is he sends the notice to the opposite side as well as a notice to the arbitrator. Supposing the agreement says that the claimant will decide the arbitrator. Now, after Perkins' judgment, there was a judgment by the Supreme Court which says that you cannot have your own arbitrators. So, consent of the arbitrator is taken. A declaration is taken under the schedule of the Arbitration Act, schedule saying that a declaration of independence. This is, I think, the 5th schedule. You give a declaration of independence that you have no affiliation with either of the parties, you have no direct or indirect interest in the dispute. You give that statement, and then if the other party agrees, you move in for arbitration. If the other party does not agree, then what is the remedy? Then you file a Section 11 petition before the court. Then the court will appoint the arbitrator, or you can file the Section 8 petition. This is the method of moving forward. And before you plead, you should know the law of limitation as well as the law on the substantive claims in the arbitration. Do I have more time or should I hurry up?
No, you have time till at least 6:40.
Okay.
There's enough time.
Okay. Because I have almost come to the end. I believe there was going to be a question and answer also.
Yes, ma'am, that also. So
Okay.
basically, it's flexible. It depends upon the person.
Okay, I can finish in 5-10 minutes. Is that
Yeah,
all?
definitely, ma'am. That's not an issue. Totally fine.
Okay. So I'm almost on my last slide, second last slide. This was again on the law of limitation and the substantive claims in arbitration. That if the claim is in the nature of the set-off, then the same law would apply if there was a set-off in the court, and the same kind of pleadings would come in, same for counterclaim. And if before the filing of the counterclaim, the claimant has given a separate notice of invocation, and the date of that would be relevant in the deciding of the disputes in so far as the limitation is concerned. That's what I wanted to say actually. Now, before ending this, I wanted to talk a little about articulation. I did say that you've been doing this certificate course, and I really congratulate this institution for bringing this course, because this is something that needs to be emphasized. Your reputation as a lawyer, as an arbitrator, comes out from your drafting. And what is drafting? Drafting is nothing but your communication. You're communicating to the court that this is what I want, this is how I've been hurt, and this is what is due to me. You're basically communicating. Even your arguments are in the form of a communication. So it is an art. This drafting is really an art. And just like I can't teach you how to paint, I can't teach you how to draft a pleading. It will come with experience. You will make your errors, and by trial and error method, you will learn. But there is something called articulation. The better you can express yourself in words, the better you are. And if you're not very good at English, that is not really a limiting factor, because it can be overcome with practice. I would encourage all of you, because drafting, of course, I was talking about in the context of pleadings in arbitration. but you can draft anything, whether it's a letter. Conveyancing also, I'm sure you would have had a feature of this course.
Yes, ma'am.
Yes, something dedicated to conveyancing, something in the civil courts, something in the writ courts. So whatever you draft, in fact, even a love letter you write is really a drafting. You have to get your point across. So your articulation is important. You must know what to write, what to omit. That's where I will rest my case. Thank you so much.
Thank you so much, ma'am. Any student has any query with respect to the lecture delivered? If you have any query, you can unmute yourself and go ahead. Himanshu, you have raised your hand.
Yes, ma'am.
Yeah, please.
Good evening, ma'am. I am Himanshu.
Good evening.
I have queries related to the jurisdiction of the arbitral tribunal.
Yes, what is your question?
Ma'am, that section number 14, that is related to the termination of a arbitrator after appointment in section 11, if he is not deemed fit for the arbitration.
Yes. Of course, this is nothing to do with pleadings, but section 14 says failure or impossibility to act. So if, for instance, I am appointed as an arbitrator in one case, and let's say I have to go for surgery, and there's a time limit hanging on my head. So I will write a letter saying I'm unable to do this. So then my mandate will end. Then whether it is a privately done thing through section 21 or a court mandated thing through section 11, then they go back to the same procedure to appoint a fresh arbitrator. I hope that answers your query.
My question was relating to that section 14 comes in the preview of section 42. That is 42 is also related to the jurisdiction.
Yes. Yes. So what is your question?
Ma'am, once a case was filed in a civil court, they were saying that you had gone in section 14 also, and you had filed the appointment of arbitration in section 11 in High Court. You had to go according to section 42 in High Court for filing the set. They were going for a set aside in civil court.
I haven't understood what.
मैम पहले तो वो है ना सेक्शन 34 के अंदर सिविल कोर्ट में गए फॉर सेट असाइडिंग द आर्बिट्रल अवार्ड.
हाँ.
और जो सिविल कोर्ट है वो उनको पार्टी बनाने के लिए कह रहा था कि सेक्शन 42 के अकॉर्डिंग आपने पहले जो एप्लीकेशन फाइल की थी ना,
कौन सी एप्लीकेशन? सेक्शन 11 की के 34 की?
14 की मैम. उन्होंने आर्बिट्रेटर चेंज किया था.
अच्छा, तो नहीं, बट यू सी 34 is a challenge to the award. Award will come after the arbitrator has given his final verdict.
तो मैम वो यूं कह रहे थे कि जो सिविल कोर्ट है ना, सिविल कोर्ट कह रहा था कि आप हाई कोर्ट में ही फाइल कीजिए जो ये सेट असाइड का है, या आप हमारे सामने जुरिसडिक्शन नहीं आएगी ये, क्योंकि सेक्शन 42 कहता है कि आपने जो पहले एप्लीकेशन फाइल की है ना, तो बाकी सारी एप्लीकेशन उसी कोर्ट में जाएंगी.
बिल्कुल ठीक कह रहे हैं. तो क्वेश्चन क्या है?
क्वेश्चन ये है कि मैम सेक्शन 14 है ना, जो सेक्शन 14 इज इक्वल टू 11, हम कह सकते हैं कि जैसे
11 इज इक्वल टू नहीं है, प्लीज.
जैसे अपॉइंटमेंट ऑफ आर्बिट्रेटर हुई मैम, यहाँ पे भी तो नहीं.
आप जो कहना चाह रहे हैं अब मेरी समझ में आया कि जो पावर हाई कोर्ट को दी हुई है आर्बिट्रेटर अपॉइंट करने की अंडर सेक्शन 11, वही पावर आएगी इन केस ऑफ सेक्शन 14. इज दैट योर क्वेश्चन?
यस मैम. 11 जो है ना वो प्रीव्यू में नहीं आता 42 के.
यस. यस.
तो मैम ये हाई कोर्ट नहीं जाएगी ना?
क्यों? अगर हाई कोर्ट ने पहले किया है अपॉइंट तो हाई कोर्ट ही जाएगी ना.
तो सेक्शन 14 और 11 मतलब अलग है?
बिल्कुल अलग है.
नहीं, वो अपॉइंटमेंट
आप समझिए, आप एक मिनट, अब आप मेरी बात समझिए. मेरे को ना कुछ प्रॉब्लम हो रही है या तो आपको समझने में. पहले आप सेक्शन 11 में एक हाई कोर्ट में दरख्वास्त डालते हैं फॉर सीकिंग एन अपॉइंटमेंट ऑफ एन आर्बिट्रेटर. लेट्स से आर्बिट्रेटर अपॉइंट हो गए. लेट्स से मिस्टर स्टीफन किंग अपॉइंट हो गए आर्बिट्रेटर। अब स्टीफन किंग कहते हैं जी मैं तो बीमार पड़ा हूँ हॉस्पिटल में, मैं नहीं कर सकता आर्बिट्रेशन, तो मैं ये मैंडेट वापस करता हूँ। तो वो 14 में उसने फेलियर कर दिया टू एक्ट, ठीक है।
यस
तो
मैम।
फिर उसके बाद फिर आप फ्रेश अपॉइंटमेंट के लिए फिर आप सेक्शन 11 के प्रोसीजर से ही जाएंगे ना।
यस मैम।
यही तो है।
नहीं मतलब ऐसी जजमेंट है कि सेक्शन 11 जो है ना उसकी प्रीव्यू में नहीं आता 42 के, कि जैसे
हाँ,
आपने कोई एप्लीकेशन फाइल की तो सेक्शन 11 के अंदर आपने कोई फाइल किया ना हाई कोर्ट में, तो वो सेक्शन
हाँ।
42 के तहत नहीं आएगा। मतलब आप उसको ये नहीं मानोगे कि
So
आपने
you're trying to tell me that this is a judgment pass that 11 is not under preview of 42, but what does that have to do with pleadings?
मैम बस ये क्वेश्चन था मेरा इसके रिलेटेड कि
ये
ये
क्वेश्चन
सेक्शन
नहीं था, ये
42 में आएगा।
असर्टमेंट थी। चलिए गुड। हाँ जी, और कोई?
Anyone else wants to ask any question? I don't see any raised hand. Okay, I don't think anyone has any other query. Okay, one person has raised. Ask her. Yeah, please.
Ma'am, if by chance the other party did not agree to the arbitration, the judgment has passed by the arbitrator, then what will happen?
Which point are you talking about? See, there are various stages. First is the first arbitration agreement. When you're making a contract, you say that we will refer these disputes for arbitration. Are you talking about that stage?
Yeah,
Or
ma'am.
are you talking at the stage of section 11?
Ma'am, the fourth and the last stage, that after the arbitrator had told that this much money you have to pay. For example, I'm the defaulter. So court has told me that this much money you have to pay. So I denied it at last moment, that I'm not happy or I'm not adhering to this point. And
Okay. Then what happens is, like you file an execution in civil cases before the
yes,
court.
ma'am.
Similarly, there's a provision under section 37 of the Arbitration Act where you can file for execution. If the other party says, I will not pay, then the party who has received the claim can file a section 37 application petition before the court and say, kindly execute this award. And then the court will follow. I mean, they will file, they will give directions for it to be executed, whether attachment has to be done as it is done in the other civil cases. So it's not as if the person is left remediless.
Or ma'am, if the person walked out before the arbitration start, the very first step of the arbitrator.
Then it will be ex parte. If you are walking out of the arbitration, then you must know the pitfall, na? What is ex parte? If a person is given the notice that you please come for arbitration, he comes, he maybe does not give his statement of defense and he walks out. कर लो जो करना है, यही बात है ना? हाँ, तो उसके बाद क्या होगा? वो 1-2 बार नोटिस इशू होगा, आर्बिट्रेटर इन कीपिंग विद द प्रिंसिपल्स ऑफ नेचुरल जस्टिस वो कहेंगे इनको नोटिस भेजो, 1 बार 2 बार पब्लिकेशन करा लेंगे एट बेस्ट अंडर ऑर्डर 5 रूल 20 ऑफ द सीपीसी। पब्लिकेशन के बाद वो जिम्मेवारी खत्म है, यू आर डीम्ड टू हैव सर्व्ड देम। उसके बाद वो आए ना आए, फिर आप एज अ डिफेंडेंट आप अपनी बात तो रख नहीं पाओगे, फिर क्लेमेंट जाने और आर्बिट्रेटर जाने, जो मर्जी अवार्ड पास हो, एटलीस्ट अगर आप पेश होते हो और यू कैन पुट योर साइड ऑफ द स्टोरी, बट इन योर एब्सेंस व्हेन दैट इज डन and after due process has been followed, it's called making the party ex parte. सीपीसी में है उसका प्रोविजन ऑर्डर 9 में, ठीक है। एक्स पार्टी करने के बाद अगर आपके खिलाफ अवार्ड आता है तो इट विल बी एग्जीक्यूटेड बाय द कोर्ट व्हेन इट इज शोन कि आपको नोटिस गया, कोई प्रिंसिपल ऑफ नेचुरल जस्टिस विशिएट नहीं हुआ, यू न्यू के मैटर चल रहा है and you chose not to come for it, then you suffer the consequences.
मैम तो ये पनिशमेंट होती है, लाइक जेल एंड ऑल समथिंग लाइक दैट?
नहीं, देखिए जेल वगैरह जो होती है ना, वो होती है एज पनिशमेंट इन मोस्टली क्रिमिनल केसेस और मे बी इवन इन केसेस ऑफ contempt
Contempt, yeah.
But arbitration, as I said, was creature of contract. In contractual disputes, जेल
हाँ, तो नहीं
तब
होती है।
होती है अगर अगर आप पेमेंट ना करें, आपकी अटैचमेंट के बाद भी रिकवरी ना हो, तो फिर वो प्रोसीडिंग्स शुरू हो जाती है. बट इट्स वेरी रेयर बिकॉज यू आर आस्किंग फॉर सम अमाउंट ऑफ मनी. कॉन्ट्रैक्ट में ज्यादातर होता है यू आर आस्किंग फॉर मनी. द निटी ग्रिटी ऑफ इट इज मनी. तो वो मनी से रिप्लेस हो जाएगा ना. Why should you put the other person in jail?
Ma'am, but if a situation is like that, the person is not capable of paying any money, like he bankrupt or
देखिए,
whatever.
if you are not paying the money, then there are better remedies ना. I can get your house attached. उसकी सेल से मैं अपना ड्यू ले लूंगी. I can get your bank accounts attached. I can get your FDs attached. Why should I send you to jail? उससे मेरा क्या फायदा होगा? मेरा पैसा कैसे मिलेगा?
Like he don't have any house. It's the situation. He don't have any house in his name or something like that. He's showing the world that he's a bankrupt or something like that.
हाँ, फिर इंसॉल्वेंसी प्रोसीडिंग्स होंगी डिपेंडिंग ऑन.
Fair.
अगर तो वो कंपनी है तो इंसॉल्वेंसी प्रोसीडिंग्स चालू होंगी फिर.
Okay. Then the company owner will pay. The shareholders will pay.
Company will pay.
Yeah. Thank you, ma'am. Thank you so
Okay,
much.
welcome. Thank you. Anything else?
Any other
I didn't
question?
receive any question on pleadings.
I think it was all clear to them. Anyone has any question? You can raise your hand. Okay, I think no one has a question now. And on that note, I would like to thank you, ma'am, on
Thank you
behalf
so
of School
much.
of Law FIMT for taking out time from your schedule and delivering such an insightful and knowledgeable lecture. We greatly
Thank you
appreciate
so
the time and effort you have put for our certificate course.
Thank you. And I want to thank FIMT and I want to thank all the students here for their patient hearing and my blessings to all of you. Thank you so much.
Ma'am. Thank you.
Okay, bye. Can I leave now?
Yes, ma'am, you can leave.
Okay, thank you.
I will end